Good evening, and thank everybody for coming. My name is Latrice Langston, and I am the president of the Beta Sigma Alpha chapter. Tonight, we are going to be talking about estate planning. What is the state of your estate? This topic is very dear to my heart, and it's something that we are going to explore in detail over a series of workshops. So, without further ado, Sora Angela and Sora Linda is going to come and introduce our speaker.
Good evening. Attorney Candice Milard is a native Oklahoman, graduating from Millwood High School in 2001 and Langston University with a BBA in Organizational Management in the fall of 2005. Attorney Milard graduated from the University of Oklahoma College of Law in 2010 and passed the bar the summer of 2010 and has been actively practicing law since. Attorney Milard is the owner and managing partner for the Milard Law PLLC, a civil practice firm in Oklahoma City, Oklahoma. In addition to being an attorney, Candice has been a member of Alpha Kappa Alpha Sorority Incorporated since the fall of 2003. Candice has been a member of Beta Sigma Omega chapter for 14 years, having transferred in 2008. Attorney Milard is married to Gregory Milard and is the mom to Gavin and Adam. We look forward to hearing her presentation. Attorney Milard.
Good evening.
Good evening.
Like she said, my name is Candice Milard, and I'm really happy to be here. I've been in private practice for about almost 5 years, and over the years, my practice has evolved to include a number of areas of civil law, including estate planning. I also do some work in probates and other areas that deal with planning and really disposition of a person's property once they pass away. But as a disclaimer, even though I've been practicing law for the past 12 years and everything, my point here is not to solicit you to my firm, of course. Really, our point is to engage your mind. And so we really want to engage you to think about what is the state of your estate and how do you want to dispose of your property upon your passing. I know one of the big things that people always say is, we essentially live our lives trying to avoid death, right? And so nobody ever wants to talk about what happens when we pass away. But we would really be doing ourselves a favor, and really our loved ones too, if we really just took that, in the grand scheme of things, that really minuscule amount of time and actually planned out or made some plans, at least put some things in place in order to set forth the disposition, the distribution, the management, whatever it is of our estate once we pass away. It minimizes a lot of things, time, but it also minimizes the burden upon your family to get your affairs in order after you've passed away. So I think we're working on some slides. And while she's working on that, really, the big question is, what is estate planning? That's our base level, that's our ground foundation. What exactly is estate planning? And kind of like I've alluded to, by definition, estate planning is the preparation for distribution and the management of a person's estate at their death through wills, trusts, insurance, and a number of other tools. Those are probably the ones that we hear about the most, but a number of other tools in order to dispose of our property once we pass away. Estate planning assists us not only with, again, reducing that burden upon our family members, but it also reduces the administration costs and also your transfer tax liability. So getting your affairs in order will assist with that.
I have the second slide up, so if you're ready for the third slide, we'll go ahead and move on.
Okay, why is estate planning important? Okay, so we know kind of what estate planning is, right? We have at least a working idea that estate planning is meant to assist us with the management, the distribution of our property once we pass away. And so the next obvious question is, why is it important? And so like we talked about before, it's important in order to, for us to decide, for you individually, to decide what happens to your property upon your passing. You can also choose who distributes your property. I don't know how many times I've had folks come to me and they say, you know what, I got 2 kids. You know, I think Sheila's a little bit better with money, and William is great, he's my oldest, but I really would like for Sheila to do it. And so, estate planning allows you to choose who distributes your property after your passing. The person who's going to distribute your property is known as the executor. And it's interchangeable with personal representatives. So if you're talking about an executor, an executrix, a personal representative, we're talking really about the same person, the person who has been given the responsibility of distributing your estate once you pass away. It's not on the slide, but estate planning also allows you to decide who gets your property. So maybe you want your China collection to go to your grandkids instead of your child. You know, maybe you want your car to go to, a friend. Maybe you want to donate a number of things to charity. And so, again, it allows you to determine who distributes your property and who receives your property. The most 2 common, I put it here, but we'll talk about it again, wills. Wills must be probated. Probate is the court procedure during which the estate is distributed, during which your estate is distributed to the persons or persons you outline in your will. Just a caveat, whether you have a will or not, your estate likely also needs to be probated. If you do not have a will, the area of law that takes care of the distribution of your estate is called succession. It can get to be a very lengthy and wide area depending on whether you have children or not, whether you have a spouse or not, whether you have living parents. And so I remember in law school, you start with this one person, but your web might get to be this big depending on how many different people go through your lineage and might be able to have the opportunity to take from your estate. The other tool that's used or talked about a lot is the trust. You can use a trust to avoid probate. And we're going to talk about these a little bit more in depth in just a minute, but I want to just kind of give you an overview, and I want to put some things in your mind, kind of buzzwords, things that you might hear. So trust allows you to avoid probate, but you must account for your entire estate if you're going to try to avoid probate. So if you leave something out, something of value out, then there might be a likelihood that you still have to probate.
So if you put your house in the trust but don't put your car, it can still be probated?
Cars, not so much, because the entity that governs your car really has it set up to where a family member can really go in and have the title to your car changed after your passing. They just need to provide certain documents. So you don't have to probate just on a car. But if you have say you put your house in the trust, but you did not designate anybody to take your life insurance or your retirement or something like that, then you might still need to probate, right? If there's nobody designated to take those funds. So the next question is, what is in your estate? So we know what estate planning is. We know why it's important. So what is in your estate? Everything. The clothes on your back, the furniture in your house, your rental property, your commercial property if you own it individually, your bank accounts, your investment accounts, stocks, bonds, whatever it is, your retirement accounts. My mama has an angel collection. That's part of her estate. My grandmother collected china. That was part of her estate. Your jewelry, your art, everything. All of those things are part of your estate. And really, us that are the savvy, I won't say us because I'm not going to say I'm the most savvy, but you want to make sure that when you're doing your estate planning that you do as much distributing as you can. I don't know how many times people are in a scenario where grandmama passes away and, oh, I gave her this and so I'm going back to the house to get it. She wanted me to have this. She didn't write it down, but you believe that that's what happened. Well, if grandma has simply written it down, we know who was supposed to get what. All right. Go ahead.
So with the house,
Mhm.
and so, and then the contents, so when you put your house, like, do you set the house and the contents, or do you have to handle the contents or how the distribution of the contents separately from the house in and of itself? If I make sense?
Yes, you are. And so if your house, that piece of property is simply in the estate, but you don't say who gets the couch and the refrigerator, in theory, depending on the family, that could be an issue.
That's what I was like.
Depending on the family, but in theory, you can put the house, and then if you put it in trust, then you can also outline some of those larger things that you want to also be distributed. I'll get to it in a minute, but just so that I don't forget, a lot of times what people also do is you create a trust, but you also do a pour over will. And the pour over will is going to direct you to look at the trust, but it also has some of that additional language that I want this person to have this, that, and the other. And it helps, they work together as one whole document. Or they're two separate documents, but they work together, I guess is the better way to put that. Okay, so going along.
Question.
Go ahead.
I have a question
Go ahead.
about the pour over will. So if you have a trust and then you have the pour over will that still have to go through probate?
No, because the pour over will directs you to the trust.
Gotcha, okay.
All right, so we know what estate planning is, we know what's in our state, why it's important, a few common terms. And I want to discuss these early because as you're going through your estate planning, these are things that you'll hear. And for me, and lawyers and anybody else who works in estate planning, we understand, but sometimes we get lost in the sauce and don't understand that everybody doesn't know what those terms mean. And there's a full class on wills and trusts in law school. You can go further into property, all that stuff. And so it went away. So the first one is a person being testate or a person being a testator. A person passes away testate when they actually have a will, right? So if you have done your estate planning, you will have been deemed to have passed away testate. You are the testator if you have executed a will. Intestate, I was talking about succession a moment ago. Intestate, or a person is deemed to have passed away intestate if they didn't do any estate planning. And that's when those laws for succession that I was talking about come into play. An heir, right? We hear about heirs all the time. An heir is simply the person who inherits property under a will or really by law. Again, we talked about succession and intestacy, so you're still an heir if grandma did not have a will.
So we joke all the time. My daughter's an only child,
Mhm.
and she jokes all the time that when y'all die, I get everything. Is that the way it works? If we don't do any type of will or estate planning, she's it, she gets everything, or can someone come and contest?
In theory, that's correct, right? So if when you pass away, she's the only child, then in theory, yes, she will take everything.
Okay.
If for any reason something happened, she passed away, if she didn't have any kids, that's when you get into that bigger umbrella.
Okay.
But in theory, yes, that's probably what's gonna happen. You also hear about devisees, right? And a devisee is a person who receives property under a will. So if I put in my will that Angela is going to get my China collection, she is a devisee under my will. Legatee, Legatee, legatee. It has to do with legacies, right? And so a person is a legatee if they've been given some real property. Real property is real estate. So land, house, buildings, whatever it is, that is a legatee. I had a case not too long ago where a gentleman was given a life estate, which basically he was given the option to live in a house for the duration of his life until he passes away, until he's incapacitated, right? And so he's a legatee because he received a piece of real property under a will. He doesn't have any monetary interest in that property, but he has an interest in remaining in that property until he passes away. So legatee. I talked about it a minute ago, but it's also on this slide. Personal representatives and executors. They're interchangeable. Technically, if you have a will, the person you appoint in your will to take care of your affairs is the executor. But I don't know how many wills I've read that it says such and such is my personal representative in the will. So the terms are used interchangeably. If you use it in front of the court, they're not going to say very much to you. If you use it in your documents, nobody's going to correct you and say, no, you're wrong, and you can't. You can't have this, you can't do that, because you used the wrong term. They're interchangeable. Personal representative, executor, executrix are the persons who manage the legal affairs of a person through their incapacity or death. They're the person named to carry out those provisions on your behalf once you pass away. Are there any questions before I go?
So if I don't want to fight my daughter when my husband dies, in case things, go crazy, I need to make sure that I have some sort of will or some sort of documentation, estate planning to say, when he dies, I get everything and then I can give you what I want.
Well, that's a different scenario.
Okay.
Right?
Okay.
Because you as a married person can't distribute all of your property through a will because you have a spouse.
Okay.
Right? Because your spouse still has some entitlement to parts of your estate, especially if you guys own a home.
Mm-hmm.
Usually when folks buy homes together, they're purchased with the deed is in joint tenancy, which means that both of you own the entirety of the house, right? I don't own a half interest of this house. This whole house is mine and this whole house is yours. And joint tenancy is usually with survivorship. So when you pass away, he gets that whole. His interest remains whole, is unharmed by your passing, right? You do need to probably take some steps to show that he's passed away so that when you pass away, your title isn't all messed up.
Mm-hmm.
But you still own that. And then under succession and all those different things, it can, honestly, you could get into estate planning, wills, trusts, all this stuff. You could run scenarios and everything all day and still never get to the bottom of it, right? But your scenario is a little bit different in that your husband still, or you, if your husband passes away, you don't have to fight your child for the property that you've been working for because you still have entitlement to a great deal of that property.
Okay, so as long as both of our names are on everything, then that's how it works.
Yeah, I mean, the
In the
simple
simplest
answer-
form.
The simple
Okay.
answer is yes.
I probably need to come to your office. You're not gonna get past slide 3. Last question is though, so like for a married couple with no children, so does you, like, we don't have a other than each other, but when that last one.
So, married couple with no children, right? If, once that second person passes away, just for, keeping it simple, that's when those laws, if you don't do any estate planning, that's when those laws of succession again are gonna come into play. So do you have, living parents? Do you have, siblings? Do you have aunts and uncles? And so it'll start, moving.
So
I
if you
guess.
both have siblings, is there, okay, and this is the thing, that's what I said, I'll come to you.
Yeah. It can get, it's simply complicated, I guess is the best way to put that.
Okay, this is a kind of tying into the heirs. Well, really more, this is a question about the executors. So if you have a trust and you're both listed, the spouses are listed as executors of the trust, right? Then one passes and then the living one becomes the executor, but then say both pass, then do the children, the heirs become the executor? And then if so, I'm tangling the web here. If so, if the oldest child becomes the executor, then who's to say that executor follows the plan? You know what I mean? What you have outlined. So would you need to insert a third overseer to make sure that the things are divvied out amongst the children properly, or how does that work?
Well, not quite. And I just realized that a term that's not here, that really should be here, is a trustee.
Okay.
And so when you have a trust, the person who administers the trust is called the trustee,
Okay.
right? And I think it's actually on another slide, but I tried to put as much information up front to you as well. But there'll be the trustee. And so when you create a trust, you name a trustee, and most times people also put in a successor trustee, right?
Mm-hmm.
So if, Billie Jean can't be the trustee,
Mm-hmm.
then I want Jim Bob to be the trustee. And without jumping too far ahead, a person who is named as a trustee has what's called a fiduciary relationship. You are expected to act with the utmost, with faith, with honesty, everything. The highest level of trust is expected of you if you are the trustee. And really, it should be of the personal representative and executors too. They don't quite define it the same way. But a trust is defined as a fiduciary relationship. And so you are expected to take all the care that you can to do it correctly. And there are mechanisms in place to get rid of a trustee or an executor or a personal representative who is being wasteful, who is not doing what they're supposed to be doing, who aren't complying with the wishes of the person who's passed away. And so, if they went and spend up all the money, then the other person needs to say, you know what, nah, we're gonna take care of this for me for all intents and purposes. Did that answer your question?
Mm-hmm.
So succession,
Yeah.
I don't know if you're gonna talk about that later, but, so in Oklahoma, succession is, so when my mom passed,
Mhm.
of course, my father's already deceased,
Mm-hmm.
my brother's deceased, I'm in. But because she didn't list a beneficiary on her, I think it was her retirement, they trying to give something to my niece and nephews. So, because they get his part,
Mm-hmm.
so,
That's where that went, I mean, you know, I think, and not to cut you off, but just as
Yeah.
to put it in your mind, I think I did a probate not too long ago where I think there was 7 or 8 kids. One child had predeceased and she had 3 or 4 kids. And so where we distributed 1/8 to all the kids, that person who had passed away before was then divided into thirds.
okay.
And so, you know, that's how that went, I mean, it can get complicated.
Well, that was my question. I was just, I mean, I don't have a problem with them.
Yeah.
I was just trying to figure out the division, like
Yeah.
how it was divided.
Yeah, and so if someone has predeceased, that's what they call when an heir has passed away before the person whose estate you are trying to distribute, then their portion of the property is then divided amongst their heirs. And depending on who's in their tree, I mean, you could be divvying that out forever. You know.
Can you decide not to do that? So if, let's say I have 3 kids, one of them unfortunately passes, and their kids are just acting a fool, and I don't want them to get any of my money, can I write that into my will and all that stuff? Okay.
Yes. You can cut them out.
So,
You can cut them out.
Okay.
so if you had, so let's say, so my brother passed, but let's say he didn't have any children.
Uh-huh.
So would that mean I got everything?
No.
So what would happen in that case?
I can't say for sure. For sure, but before they gave you the entire thing, they would look to divide and distribute his piece among whomever. So if he didn't have any kids, if there's
A spouse.
I know you, but they would look to see, okay, are there some other cousins, or is there an aunt or uncle or whomever, before they throw his piece back over to you. Succession is a tangled web.
An aunt or an uncle?
Yeah.
Like your mother's siblings.
Really?
Yeah. Yeah. And I'm gonna throw it out here now. So if you're not familiar with the Oklahoma statutes, how many people have ever heard of OSCN? Right? OSCN, I love it. And the reason why I say I love it is because when I look at other states and try to get information from other states, be it their statutes, be it looking up cases, they don't have anything. It's the most comprehensive for me information. I can click, and even if the information is old, valuable, inaccessible in the way that I need it, I know that there's a place I can go. I tried to do some stuff in California, and they have a separate system for every county. Even it was a mess, and so I was highly unhappy with trying to get information on a case in California. But OSCN, you can look up Oklahoma statutes, and wills and succession are in Title 84.
What does OSCN stand for?
Courts Network. Something Courts Network.
I can't remember. Oklahoma State Courts. Okay. Oklahoma Supreme Court Network, and it's OSCN.net. Don't put in .com.
Don't do it .com.
Yeah, because you're not gonna get it. .net.
It's also a good dating tool.
Huh?
It's a good dating tool.
That's how I was introduced to it.
You can use OSCN for a wide range of things.
A variety of things.
Yes. So that's a whole nother seminar, discussion, workshop, all of that. The various want to see it like so wrapping it back around, I said we would talk about the two bigger tools, right? So wills and trusts, we talked about them a little bit. Simply speaking, your will is the instrument by which a person provides for the disposition of their property. And I talked about the fact that wills of succession are at Title 84. Any person of sound mind, sound mind. So keep that in mind, I guess. I don't know. Sound mind and over the age of 18 can create a will to dispose of their property. And people always tell me, I don't have enough, whatever. Really, creating a will, you don't have to have a lot of property. We talked about what's in your estate. You don't have to have a lot of property, and there's probably a lot of evidence to support that individuals who have more modest estates probably need estate planning and to create a will more than people who, we would deem to be wealthy, because very likely those individuals have some other mechanisms in place that are going to make sure that their property is distributed. So, sound mind, I bolded them, and over the age of 18 can create a will. In Oklahoma, a will may be handwritten or typed. You've heard about, you see it on TV, well, I wrote my will out on a napkin or whatever. In theory, that's valid in the state of Oklahoma as long as it's totally handwritten, it's dated, and it's signed in that person's own handwriting is valid. It's called a holographic will. They're valid. They're not the greatest because most people who write down things on a napkin forget to appoint a personal representative. Maybe they're not near as extensive as really you want your will to be, but they do exist, holographic wills. Otherwise, typewritten wills, a will that you sat down and you did with your attorney, your estate planner, whomever, really are going to get the job done better for you. And in order for the will to be valid, it has to be signed. It must be signed by the person making the will or by someone in their presence. So if I can't write, maybe I have bad arthritis in my hand, I can ask Angela to sign it for me she has to be there with me and she has to attest to it in my presence. All those things have to be put in place in order for that will to still be valid. It has to be signed. Your signature must be in the presence of two witnesses, or in the case of someone signing for you, I have to be there, you have to be there in order for it to have the authority. And then at the time of the subscription or the signing, you have to declare and attest to the witnesses that this is your last will and testament. I'm signing this will. This is my last will and testament. Is really how that in theory should go. Whether those words always get said, those signatures need to be affixed. Two witnesses, and they must sign their names at the end of the will and in the presence of the person making the will, the testator. Any questions about the simple aspects of a will?
What if you change your mind after you've made a will about some things?
Your will, your trust are 100% able to be changed. My opinion only, is to create a new one. Don't go in, you can't go in and try to scribble out and rewrite or whatever. Create a new will. Once you create a new will, any other will that you had before is automatically revoked. It's null and void. Once you, at the time of your passing, whatever the last will you wrote and signed, attested, you met all those requirements, that's the one that's going to govern. So it doesn't matter if 15 years ago you made a will and you gave everything to your sister. If you made a will yesterday and you gave everything to your brother, then the one that you made to your brother is the one that's going to be the one that's used.
Does it have to be filed somewhere? Or if we just find it in a drawer at the house, dated, like, how does that work?
There isn't I've tried to find, there is not a full registry. There was a time where parties could take their wills down to the county clerk and you could file them, but that's not a necessity now. Really, what's most important is that those persons that you have outlined to distribute your will, so your personal representative, your children, that they know that they have a copy. Now, do you want 100 copies of your will out there? Not necessarily. But if you have 2 kids and a third person is meant to be the personal representative or the executor, then you want those persons to have it. And or put it in your safe, you know, so that people know where to find it. Tell them, hey, my will is here. And really, it's my recommendation that you go over your will before, with those individuals too, so that nobody's having to guess anything. They know where it's at, they know what's in it, right?
So let's say, I'm sorry.
No, ask me.
So let's say, my brother has a will that he gave me a copy of. I pulled a copy out and his wife is like, that's not what he wants. So she can contest the will.
Will contests, they are outlined in Title 84. You know,
I'm just trying to figure out like what's the most solid, for lack of a better term, tool for planning your estate. So when you're gone, like it's not a bunch of, she didn't want that, yes she did, no she didn't.
well, that's why when you have a will, and honestly, when you have a trust too, they're not just simple pieces of paper. They have to be in the presence of witnesses. They have to be notarized. And I don't think that we put that, it has to be notarized. And so that's an official document. And so if I'm standing here with your will and you've signed it, you've done everything, it's notarized, I don't get to say that's not what you wanted because you told me what you wanted. And really, it is wholly against the spirit of the will and estate planning and everything for you to decide what I wanted when I told you what I wanted in my documents. I mean, it happens.
No, yeah.
But it is totally against, and I saw your hand, I didn't miss you. But the courts, in my opinion, have taken any will contest that I've had pretty seriously. And, you know, you don't get to just run in and say, no, that's not what she wanted, because we're going to look at that document and say, no. What she wanted is right here. Unless you can show that I wasn't a sound mind, that I did that under some type of duress, somebody made me do it, then what I said goes.
You said that wills, though, go to probate versus trust. So, can you have both?
Pour over will.
Okay.
Yeah,
Okay. got it.
simple answer.
So the pour over.
Put your pour over will, which directs you back to the trust.
Okay.
Those documents work together.
But when you said before, if you have a will and it states everything you want, why does it have to go to probate?
So I don't know. I mean, that's the process. I don't know why wills have to be probated.
Versus trust.
Yeah,
So
I mean,
all wills have to be probated, no matter what?
they should be. Yeah,
Okay.
yeah, they should be. Now, people say, I don't wanna, I had a case where they say grandma said she did not want to go to probate, right? But in honesty, they probably needed to go to probate so that they could clear out that estate and everything could be distributed the way that it needed to be.
Gotcha. That's why.
Yeah, I mean,
Gotcha.
and I mean, when I say I don't know why wills have to be probated, that's the procedure. right? I can't tell you what the process behind it was.
But a trust doesn't have to be
No.
probate.
Mhm.
It just, whatever is in the trust is what's done.
Mhm.
And, go ahead.
Well, I had a question about the pour over will.
Mhm.
So if you have the trust and then you have the pour over will, let's say the pour over will was done, 16 years ago and things have definitely changed. Do you still need to update that pour over will, or does the pour over will, since it points back to the trust?
If you are going to change your trust, you need to make sure that your pour over will is consistent with your trust.
Okay.
So execute a new one. It won't take you that long to execute new documents. That way you revoke everything, everything's consistent, and you can move forward knowing that your documents are consistent with each other.
Would you execute 2 new documents or just the pour over will if the pour over will is the only thing that's changed? Does that make sense?
My opinion, update all your documents at the same time.
Same time, okay.
Yeah, if you're gonna update one, update the other. And if you're updating your trust, then you need to be looking at your other estate planning tools to make sure that they're consistent too.
We have a question online. Without a will, you and your siblings have to decide mama's division of assets, correct?
Succession. So in theory, simple terms, if there's 3, everybody gets a third. Assuming that everyone is alive at the time that mama passed away.
Okay.
Otherwise you're getting into those small little details. But simple terms, everybody's gonna get a third under succession. So
No one gets
you
to
don't
decide.
get to decide that you and your favorite brother are gonna take the whole estate and your sister doesn't get any.
Got it.
You don't get to decide that.
Okay.
Mama could have in her will, but you don't get to decide that after she passed away.
Okay.
So, we were talking about wills, we dived into trust, so the next thing I wanna talk about is trusts. So, trust is a written document which one person gives the right to another person to hold title to property or assets for the benefit of third party. That's a really long-winded way of saying that I place trust in someone else to hold property for the benefit of a third party. So I place my house in a trust for the benefit of my children. The trustee is, my husband. If he passed away, then maybe the trustee is my brother, or whatever. Placing your property in a trust allows, and most specifically, I think what people are trying to avoid is property issues, right? So you place your house in a trust, when you pass away, you don't have to worry about, well, I have to go and update all these documents, I need a quitclaim deed, whatever. The trust owns the property, right? And it can continue to pass on, and you can put in your trust information about how that property, that house is to be managed. So I don't want you to sell my house, right? I want it to stay in the family, and I want my trustee to take my pension funds or, my life insurance and pay the mortgage every month. You can outline those things.
So you have a trustee who, kind of follows what you outlined in the trust. But if you have life insurance, but you name the beneficiary, that doesn't have to go in the trust. The beneficiary can just get the life insurance. So everything doesn't have to go in the trust.
But you can name the trust as your beneficiary in your life insurance.
Oh, okay.
You can fund it that way, right? And that's another estate planning tool, insurance. And having a named beneficiary so that your insurance money goes to someone specific, or it goes to your trust, and your trustee knows, okay, these funds are to be distributed or they're being used to manage my property, my estate in this manner. I see.
Can you also name your, the beneficiary on your retirement, can you put that in the name of the trust? Like your 401k, can you make the trust beneficiary of your 401k?
I don't know.
Okay.
And I think it really depends on, and the short answer should be yes. But it might depend on who manages your retirement and all those things, whether they allow you to do that.
Okay.
I was saying you can put that in your trust, but the tax rate is really high. So if you put that money in your trust, the trust rate taxes it at like 39%. So it almost kind of will like bleed itself out. But they're changing the laws right now regarding that. So maybe look in like 6 months' time to see if they're gonna start to try to put them in trust if they can get the, legislature to change the tax rate.
My question was still kind of on the same topic. With trust being its own legal entity, I didn't know that you can put the trust as the beneficiary on your life insurance policy. So I just want to clarify that I'm hearing that correctly.
Yes.
Okay.
So, like I was with the scenario of, I don't want my house sold, I want to stay in, but you have a mortgage. Well, how are we gonna pay that mortgage when you pass away? You're not working anymore, and so how are you gonna pay for it? And so that's a way to fund your trust.
I have a question. Somebody text me a question instead of placing it in the chat. They want to know, is it okay to use online kits like the Susie Orman Will and Trust kit?
That's it at all. That's it.
You wouldn't advise it?
No, and nothing against any of those things. I mean, and from a wide standing standpoint, from a general standpoint, but when you're using those platforms, they are meant to appeal to the masses, right? And so things might not get drafted or completed the way that they should under the law. And also it could be against really what you intended. And so really the best thing to do is to sit down with somebody and really outline what it is that you want instead of typing everything into, using a kit or something like that. Now, if you want to, it's better than nothing. But
We have another question that came through on our Facebook Live. Is there a limit to how many trustees you can add?
no, I mean, in theory, no. But you don't want this long line of folks. So, my opinion, if you're going to appoint a trustee, then maybe if you think that if you don't want to take anything away from your other child, you got 2 kids, they can be co-trustees, co-personal representatives, whatever it is. I don't think it should go any further than that, because then you're kind of defeating your purpose, because everybody can put their 2 cents in as to, what should really happen. I mean, you have it written out, but everybody's gonna give their opinion on it anyway. And so empowering 1, maybe 2 people to jointly, not on their own, to jointly work on your behalf is probably as good as that's gonna get out. Don't go any further than that. Now, you can have some successors, right? And most people don't need to go any further than maybe 1 successor or 2. You never know what's gonna happen. The person that you appointed initially may not be able to. Maybe they haven't passed away, but maybe they're really just not in a position to administer your estate. So you have somebody to take over that duty. But you don't want to get into this long line of people who can step into that role. And like I said, when you're talking about a trustee, that is a high level, the highest level of trust is supposed to be put in these folks. And so, you want to put somebody in there that is going to take care of it. Trustor is the person who given rights title. Trustee is the person who has been given that right. Most people in trust, they are the trustee until they pass away. And so you have the option to administer your estate the way that you want to. And really, you should do it in line with the documents that you put together while you're alive. And that successor trustee is the person who is going to manage your trust after you pass away. Revocable trust is the most common. Those are the ones that can be changed. Irrevocable trust cannot be changed once it's been put in place. So revocable trusts. And again, they're effective during your life. It can be changed. Trustee, you're a trustee during your life unless you appoint someone else. You can appoint somebody else to be a trustee during your life. I was talking about the pour-over will. A person may execute a pour-over will, which gives money and property to the trust, so they work together. Essentially, it says, pour over, look over here at this trust.
So your trustee, so you pass and your trustee gets the rights to all of your stuff and they decide they gonna do what they wanna do and not what your trust states for them to do. Is there any like action that can be taken against them?
Yes. So someone other than the trustee can, I'm gonna call it a contest, but it's not a contest, but they can, trying to think of the best word. There are mechanisms to remove a person as a trustee.
Okay.
So, yeah, if
But
they're,
what happens to all of the money that they already spent out of your estate?
it's a fiduciary relationship, right? So they can be liable for their waste.
Okay.
Now, real talk,
You ain't gonna get it.
Right, because they spent it.
but you know, you can take that action. So other tools in our estate planning toolbox, insurance. We talked about insurance. Having a beneficiary on your insurance ensures that it doesn't have to be probated. We don't have to figure out who it's going to be distributed to. It makes sure that your final expenses are paid. Make sure that your bills are paid. If you have, so talking about life insurance and health insurance, you know, making sure that all those things are in order are tools that you should have in your estate planning toolbox. You can also appoint someone to make sure that your children are taken care of, and when they have that insurance, use those funds also for your children. Your pension, your retirement designations, making sure that you have a named beneficiary in your pension documents, your retirement documents. Power of attorney. Power of attorney ensures that you, that should you become unable to care for yourself and or your estate, that someone can take on those tasks for you. So again, paying those bills. You know, I think that's the big one. You want to make sure that somebody's paying your bills, that you're not going into unnecessary debt, things like that. Power of attorney, healthcare directives. You can have a healthcare proxy, which this is really, in Oklahoma, that's really fuzzy territory because Oklahoma revoked, it's coming back, or the legislature is working to kind of put that back in place. But they revoked the ability for you to name somebody to make healthcare decisions on your behalf. You can have a healthcare, through your advanced directive, you can designate what happens if you become long-term incapacitated, if you're end stage, if you have an end stage illness, you're comatose for an extended period of time. You can designate someone to assist with, you can designate what happens to you during that time. So do you want life-sustaining treatment? Do you want to be given artificial nutrition?
And all of that has to be in an advanced directive.
It should be. an advance directive, a lot of times they're a signature form. So it goes through, if I'm in this condition, this is what I want to happen. I want to receive this type of treatment. If this happens to me, I want to receive this type of treatment. I had a friend who, we went through her entire healthcare directive or living will. And at the end, we were like, well, what if you pass away, what do you want to do with your body? You can just designate through your healthcare directive whether it goes to science or whatever. She wanted to, I think, she wanted her body to be intact, but she wanted to give her brain to science. You can use your healthcare directive to do that.
So who executes that? So then,
It's a written
then,
document.
no, I'm saying, so like, if I designated in my advance directive that I wanted my body to go to science, then who's then in charge of ensuring that that's what happened to my body? So am I then also pointing that back to my trust, or, I mean, you get what I'm saying? Like,
Yeah.
the hospital just like get the money.
It should be outlined in your healthcare directive. And again, if you have your entire estate plan put together in one place, then whomever is designated can provide that information to the doctors.
So the person that's actually just designated in general.
Go ahead.
Could those, be, I can't remember the word, fought against like the power attorney for my aunt and uncle, both medical as well. She doesn't have kids, but he does have kids. Sticky situation for me. But, so can his kids fight that power of attorney, that medical power of attorney to go against what he wants because I'm making those decisions?
If he has a document that he executed and they want to fight against it,
Without power of attorney and the medical power of attorney, but it might not be what they want.
you know, all these documents are supposed to be executed while, competency, sound mind, whatever. And so the purpose is for us to put our wishes in place. And so if we're going to go back and we're going to fight against everything, it goes against the whole purpose of what you were trying to do.
But they can't do that.
We fight about a whole lot of stuff that we shouldn't.
We fight about Android versus iPhone.
Yeah. So they can fight it. How well it holds up, I think their chances of succeeding are much lower because there's a written document. And again, your power of attorney has to be signed and notarized. None of this stuff is to be taken lightly. I don't get to impose my wishes for you upon you. That sounds weird because you're no longer living in these cases. But I can't decide what I want to happen to you, your estate, whatever, when you told me what you want. Did you have your hand up back there? Okay. All right. So we talked about advance directives, living wills, burial plans, things like that also are good tools to have in your estate planning because they tell us they tell those who are still here what it is that you wanted. I want to be buried in this place and I got a plot already, so you don't have to worry about it. It's done and paid for. You need to just take this over to, such and such at the funeral home. They know what to do. That takes some burden off. Maybe they don't want you to be buried there, but that's where you want to be buried. Those are the plans that you have put in place. And so really, I had a judge tell me last week, who are we to go against this person's wishes, right? And so really what we're trying to do is we're trying to ease the burden. So why would you bring the burden back to yourself? I outlined everything for you. Yes, I've outlined everything for you. Just do it. Celebrate my life. Remember the good times. It's all laid out for you.
When my mother passed away, I said a lot. Mama said, so I just gotta say it, my mama said.
And in that case, you know, what mama said was probably true, and she probably meant it in the moment. Did she put it on paper though? Is the question, right? Cause, and I see you. And not picking on you, What? I'm sorry. Not picking on you or anything, but if mama had a will, but mama got older, and she said, you know what, I really want you to have this, that, and the other. And she didn't change her will, guess what? What mama gave you in the will is really what is gonna happen or what should happen. Unless there's an agreement of everybody that maybe we do something different, but that really should not happen either because mama said what she wanted to happen.
I have 2 questions. One is from the chat and then one is my own. So, we have a question, what was the purpose of revoking the healthcare designee for the living will?
I do not work for the legislature. I don't know. And the information that came out to me, the way that I understood it best was that they write laws, and I'm not bashing anybody, but sometimes we forget about this piece that's over here. And so maybe it wasn't intentional, but it certainly happened. And so, which is why I think there's an effort to put this back into place because as far as I can tell, it was a unintended consequence.
And my question, so, and I know we haven't talked about this, and I don't know if you're gonna get to it or not, but like your bank account, can you, you can have your trust, your bank account in your trust name? No? Yes?
Yeah, I mean, I don't have it happen a lot. I mean, personal bank accounts are usually personal bank accounts.
So in the event that I pass, like, do I need to have someone on my account that payable upon death?
You can, right? So, and I had a case like that very recently where, you know, the bank account was payable on death to XYZ person, right? You can do that. It's also a good thing to have just a co-signer or someone, a joint person on the bank account so that, because what the bank's gonna do, as soon as they get wind that you passed away, they're like, no, you can't get it. But if there is someone who is a co on there who can go in and they have to show that they're actually taking action on behalf of the estate, they can't just go in and start spending that money up and use that as their own personal bank account. But having somebody on that account to ensure that some of those expenses, because maybe, you know, there were some bills that are due or something like that. So those things can be taken care of in your absence, essentially.
But if you don't want anybody on your personal account other than yourself, I'm not,
No.
serious. I mean, like,
I
I'm serious.
understand.
I just don't.
I understand.
But the trust could be a beneficiary.
Like a payable upon death, can the trust be?
Can the trust be?
I work at a credit union, and they said, if you have the trust documents, they will open up an account, a trust account, and it'll be in the trust name. You cannot, only person that can do anything is what the trust says, and the executive. Your personal account has to have the beneficiary on it. So if you don't have a beneficiary on your personal accounts, any of them savings, checking, money market, whatever, then it'll go to probate as.
And they go, and they will, then.
Yeah, they'll shut it down, just like she
They're
said.
gonna shut it down.
As soon as we get wind that the person died, we shut it down and then wait until everything happens. So, but with the trust, if you have a trust document, then you can open up an account under the trust name. So whatever the trust, like this is say William B. Smith Trust. And it'll have on there who the trustee is and things like that, you know, executive, whatever, however your trust is set up. And that entity can pay bills. You cannot withdraw, you can't do, you know what I mean, your personal, or it has to be in the trust name. And if we deposit checks or whatever into the account, it has to be in that exact name. It can't be anything else. Same thing with, tax purposes.
And so if you have a personal bank account, like, and there's no one else on there, it's going to shut down. And they're not going to open that account up until you bring those letters of administration or those
Death
letters
certificate.
testamentary
Yes.
to show that I'm the personal representative and I can get into this account. And they're watching it. And so,
So, do I understand correctly? So if you have a personal account, and you don't want anyone, to have the ability to draw on that account, you can still put someone on that account that would take care of your affairs upon your death only.
Beneficiary.
So you can put a beneficiary on your
Yeah.
personal bank account.
Right.
But they can't mess with it.
They can't, exactly, they can't. And it definitely. What she said?
no, nobody on. Did you have a question?
Yes, so speaking of beneficiaries, me being unwed with a minor child, and I have everything listed in my child's name, what would that look like if he's not of legal age, should I pass before that time, since he is the person that I have on all of mine?
So your will should name someone to be to take care of your children. So the trustee of the children, the child, whatever. And they can hold, though, if you create a trust, they can hold those things in trust until that
So I
child.
definitely have to go through a trust, like right now, if I have 401ks, bank account, health insurance, life insurance, and his name is on there, do I need to write a separate document to let those entities know that this needs to happen this way if he's not of age or something happens?
Well, putting that trust together allows all that to be put together in one place, right? And be held for his benefit.
So if I don't have a trust, I should probably get one in this situation.
And you can outline it, and so all those things can go into the trust, and you can, in your trust, put stipulations on when those funds are distributed. So I had a gentleman who came to me and he said, you know what, I got 3 girls. I want them to each take a third of my house, right? But I got 2 girls that are a little bit younger. My oldest girl, I think she can handle it. But if I pass away before my 2 younger girls get to be, I think it was 25 or something like that, I don't think they can handle it before 25, right? And so there was that stipulation on them to say, okay, you can get it at 25. And so really, I think as a tool, it's good to set aside those funds in trust so that all that is in one place and there's one person who is able to administer that for him. Because if he's getting these checks from everywhere, I mean, who's managing that? And how is it being managed?
So if they still disperse that to, he's 13, so if something happened now, and him being 13, would they disperse that to a 13?
Oh boy.
Yeah, they're gonna be responsible for it. It's simply complicated. And by no means do I have every single answer. I take it from it. I mean, estate planning is not a just a one shot. Yeah, I'm gonna sit down and it's all over here. It's something that you should be reviewing regularly. You should be changing it, updating it, making sure that your wishes are being outlined the way that you want them to. And I call it a living document. Your estate plan should be a living document. So, yeah, that was my last thing. But burial plan, all that stuff, those are all pieces of your estate plan. They all work together to make sure that when you pass away, things are taken care of, and that your family, your friends, whomever, they don't have to worry about what happens. Again, separate your life and be done with it. Are there any other questions, concerns? And all minds clear?
No,
They're not, but what you got? I guess the better question is, are you engaged?
Yes.
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 When's the next
Yes.
one?
Huh?
Yes.
When's the next one?
intriguing.
This is good.
This is good. This is really good.
Stop thinking that you don't, that if you think you don't have anything, that there isn't anything to plan for, because that's totally against it. Plan for the minimum. You never know the time, the day, the place. You just don't know. So
You surely do not. I'm a witness.
yeah, and so having a plan in place can ease some minds and some hearts.
All right.
I don't know if y'all got this. There's a document, from the Oklahoma Bar Association. It's, do you need a will or trust? It's just some additional information. It's free from the Bar Association, so you can get on the Bar Association, website and see it, but also, I think we had talked about having them, but I think they'll be available for you.
Yeah, that, she sent it to me, so I'll send it out.
Yeah,
Just send it out.
yeah.
And do you have business cards?
No. But on purpose, really, because like I said, my point was not to solicit business. It was.
But we
really-
trust you now. Okay.
And we have several lobbyists. You sit up next to one.
But yeah, it was, I did.